The Clean Water Act and the Federal Water Pollution Control Act regulates discharge of pollutants into the water. Environmental Protection Agency implement pollution control programs. Requires permits to discharge a pollutant, and it protects wetlands. Coastal Zone Management Act is administered by the National Oceanic and Atmospheric Administration and the EPA. It's voluntary participation, and federal funding is available for participating. The Coastal Non-Point Pollution Control Program and the Coastal Construction Control Line Program is concerned with pollutants carried into rivers, lakes, and coastal waters and groundwaters by water runoff. Interstate Land Sales Full Disclosure Act is intended to prevent fraudulent marketing schemes, and it's administered by the Bureau of Consumer Financial Protection. The requirements are registration and property reports. The two components include the anti-fraud provision and the registration requirement. The anti-fraud provision requires developers of 25 or more lots must provide the purchaser with a property report before signing the contract, and they may cancel within 7 days. Buyers who did not receive the report prior to signing the contract may cancel within 2 years. The registration requirements requires developers register subdivisions of 100 or more lots. Developments of regional impact include shopping centers, malls, attraction and sports facilities that impact more than one county. They want to know the extent to which the development would alleviate environmental problems, pedestrian and vehicular traffic that is generated, number of residents and employees, the size of the site, additional development generated, additional demand for or additional use of energy, and unique qualities of area. CERCLA, Comprehensive Environmental Response, Compensation and Liability Act. Responds to releases of hazardous substance. There is liability for cleanup. They established the Superfund to finance an emergency response and cleanup cost, and the program is administered by the EPA. What is a PRP? It's a potentially responsible person. It means liability for responsible parties. It can be present owners and operators. It can include past owners and operators of the site when the hazardous substances were on site, generators of the hazardous substance, and even the people who drove it there, the transporters of the hazardous substance to the site. How is liability discerned under CERCLA? There's strict liability and there's joint and several liability. Strict liabilities, we're talking about those potentially responsible people. All of them are liable. Joint and severally means one potential person or any group of people may be held responsible for all the cleanup cost. Superfund Amendments and Reauthorization Act consist of the innocent landowner defense. The pollution was caused by a third party, someone other than the current owner. They did not know that the property was contaminated when they purchased. They reacted responsibly upon the discovery of the contamination and make reasonable inquiries before they purchased it. There is a national priorities list that's maintained by the EPA. It's a list of sites that warrant remedial action. Something needs to be done. Okay. They determine which sites warrant further investigation, identify what CERCLA finance remedial actions may be appropriate. They notify the public of sites the EPA believes warrant further investigation, and notify potentially responsible parties that the EPA may initiate a CERCLA financed remediation. Brownfields legislation. Sites that the expansion, redevelopment, or reuse of may be complicated by presence of contamination. Small Business Liability Relief and Brownfields Revitalization Act enables contaminated industrial and commercial properties to become economically viable through relief from the liability of the past contamination. What constitutes environmental due diligence? Would be an environmental site assessment. You have phase 1, phase 2, phase 3. Phase 1 is a study of the past uses and records concerning sites, physical inspections, review of procedures and safeguards, analysis of aerial photos and building records, and review specific scientific reports. Phase 2, that's field testing and analysis. Phase 3 is complex soil, water, and air quality analysis. Asbestos was used as building insulation and fire retardant prior to 1978. Federal and state regulation, the DBPR licenses and regulates asbestos contractors and consultants. The EPA recommends a phase 1 assessment to look for signs of deterioration, encapsulation versus removal, which is the best alternative. Radon gas is naturally occurring. It's radioactive, may cause cancer. Testing is the only way to determine if radon levels exceed guidelines. Radon gas mitigation for homes that exceed the guidelines. In Florida, radon disclosure statements must be in the sales, contract, and leases. Lead-based paint. Residential Lead-Based Paint Hazard and Reduction Act is enforced by the HUD and the EPA. It requires disclosure of known lead-based paint hazards in housing built before 1978. The required disclosures: 1. The seller must give the buyer an EPA pamphlet, give the buyer 10 days to conduct testing, disclose known lead-based paint hazards, and include warning language in the contract. Now, landlords must give the tenant an EPA pamphlet, disclose known lead-based paint hazards, include warning language in the lease, and sign statement verifying completion, which is retained for 3 years. Some other environmental issues: sinkholes, mold, dockage, Beach Management Fund Assistance Program, and Florida Aquatic Weed Control Act. There are some exceptions to the lead-based paint law: housing built after 1977, commercial facilities, 0-bedroom units, leases for 100 days or less, that's if the tenant does not have the ability to renew the lease, and designated housing for elderly or handicapped with no children under age 6 living there. The licensee requirements is to inform sellers and landlords of how to comply, certified in writing that the licensee has made the seller or landlord aware of their legal obligations, and secondly, comply with the law even if the seller or landlord does not comply.